the sufficient time to conclude before 29 May. And we have an election analyst, Austin Aibwe, and a lawyer, Maxwell Okpara, to join us already in the studio to do justice to this. Fair?
Yeah, that's true. Thank you so much, gentlemen, for joining us.
My pleasure.
The focus right now is on the speedy dispensation of justice, but we can take a peep into the Constitution, for example, to serve as a guiding compass. So Section 288 of the Constitution and also the Electoral Act stipulates that elections in Nigeria, including petitions, of course, are governed by the elections. This, of course, means that within 21 days, it is expected that the announcements of those the results should be also made public. This, of course, also is related to the fact that the Election Tribunal shall deliver its judgment in writing within 180 days from the date of filing petitions. For a lot of Nigerians, for example, the idea is all this, particularly the 180 days and a whole lot around it, is one that has caused for a source of worry, and they want this thing speedily done. Closely also related to it is that after that, any resulting appeal must be heard, and a decision also has to be made 60 days from the delivery of the first verdict. If we take this and just oppose it with the speedy dispensation of justice, what do you think can be done to ensure that we put our legs on the pedal and we get less time in the adjudication of these issues? I'd like our lawyer to react to this.
Okay, just like the namesake Olusabakawa SAN said a few days ago that all elections, presidential election tribunal, from Court of Appeal, which is the Court of First Instance, to Supreme Court, can be dealt with and concluded before swearing in. I agreed with him to an extent. I also disagree with him to an extent. You see, there are many factors by which the tribunal can affect the speedy dispensation of this particular trial. One, the number of petitions coming to the tribunal. Two, the conduct of the council and the parties. Then three, the disposition and conduct of the panel itself. Now, there is a constitutional requirement that they have 180 days, that is on a trial court, in this instance, Presidential Court of Appeal, that has a originating jurisdiction, and the Supreme Court, that is 60 days, that has appellate jurisdiction with respect to the President. Now, when you add it up, it's 240 days, which is about 8 months. Now, that is the maximum. That does not mean that the matter cannot be had and dealt with under a month, under 2 months. It depends on the factors which I just enumerated. Now, going forward, the pre-election practice direction issued by the President Court of Appeal, both for pre-election and post-election, also gave the panel the power to abridge sometimes. Olisabakaba was using arbitration procedure as a guide, that if the panel can adopt that, they can deliver judgment under 1 week. What does that mean? There are preliminary matters that need to be discussed with, jettisoned with, before going into the main trial. So when you discover that this particular issue has been resolved at the preliminary stage, then they now focus on the main issues. So why that cannot happen in election tribunal is that the parties with their witnesses must be heard. The evidence they want to tender must be evaluated. For unlike in arbitration. In arbitration, during preliminary stage, there are some issues that must be dealt with and do away with. But on this particular issue, the first schedule of Electoral Act made provision for
electoral issues that needed to be dealt with
before going, which is the one that is going now, filing, filling the pre-trial forms and what have you. So it depends. But on my own, the panel, who are Nigerians, living in Nigerians, should understand that the expectations is very high and the tension is high. If you watch, we have been having election tribunal since 1999. But this particular one, the Okada man is analyzing this issue. The Mebaru is analyzing this issue.
He's a Nigerian.
Yes, unlike before. Somebody will now tell you that, Barrister, this 25% they are talking about, he's talking about and Abuja now. I hear them saying everybody is interested. So, and they are saying that the issue of this interim government, we have not had it before. We never had it in 1999, in 2003, in 2007, 2011, 2015, 2019. We are hearing it now. Why? Because people believe that the person we elected was not declared. It shows in the atmosphere after the declaration. The youths believe that our efforts in getting back Nigeria has been thwarted. So that is why they have left INEC, they have left the presidency, they are now in judicial arena. So everybody is looking at. So, and some people are now saying that, except we are not ready to tell ourselves the truth. I say that if we allow them to swear this person in, he will use his power to, although a lot of issues. So that's why people are calling that let them finish so that, you know what I'm saying?
Yeah,
so I think the tribunal should look at it, because I know that out of the 18 presidential candidates, up to 6 file election petition. And if you watch, it's only one panel, the same panel.
Okay, let me come to Austin, because one of the things, I mean, this clearly spells out is that we're depending on the judiciary to sustain our democracy and our peace. And some people would say that's rather unfortunate. However, if you look at some of the statements by the Leonard Silk, one thing he did say was, and I quote him, "The speed proposed here requires a radical departure from our present judicial policy, where case management plays a very limited role in judicial outcomes." And I mean, it's very clear. So speed, outcome versus believability. How do you respond to this?
Well, I'd like to start by saying that I do agree with the Lenese from the beginning to the end, because of the momentum and the focus. Like Barrister has said, the interest in the 2023 general election in the history of Nigeria is monumental. We've never had this kind of euphoria about an election. Not just in Nigeria. As I speak to you now, friends from Liberia and Sierra Leone who are having upcoming elections are asking me what's happening in Nigeria, because there is a signal that has put over to those elections. For folks in Ghana, whose election is coming up the year after, in Senegal, they're asking that Nigeria has set what they classify as a wrong pedestal in the West African region, whereas Nigeria was supposed to set a path for the progress of the continent and, of course, the global community. Now, this is what I think should happen, and do flow with the Lenese. And this is what the Lenese did before the election. There's a particular case in question, which is 25%, Section 314 of the Constitution. 25%. What does it mean? Abakuba has written to INEC to clarify before the election. This is someone with foresight. He knew that, based on the conversation that were ongoing, that the election was not going to be concluded on the first ballot, it may run into, for the first time in the history of our country, a second ballot, that we need to be able to interrogate ahead of time. He wrote to INEC and specifically demanding an interpretation. What would INEC would have done at that time was to quickly seek the Supreme Court interpretation and then make public. All of this euphoria about 25%, whether you have to win, whether you have to have 25% in Abuja, would have been nullified before the election. But no comment, no commentaries. We all had our say publicly, including some of us who are political analysts, some of us who believe that English language is what is in the Constitution, or lawyers who believe that 25% does not mean anything. Abuja is a state. We could have dealt with this. That is one. I'm not sure you need witness in that process. You don't need witness to testify whether 25% is Abuja. Abuja is a state that needed 25% to be won or not. You don't need witness. Deal with that issue, because that's a fundamental issue on the table. A second one, of course, is the drug issues and the American
allegations
that they brought in, which also trended before the election. There was a fake news at that time, if you remember, that INEC has released a press statement I can't remember the content of the press statement, but in summary, the statement was that INEC is investigating the U.S. proceedings and INEC will take action. And that was not true. These two issues, maybe for the drug issue, you could I don't even think you need witness. Maybe the witness will be an American court to say, can you come and testify that this actually happened? Otherwise, is it okay that the man, because I heard Festus Okoye, I heard various fashion of the cases, not Festus Okoye, Festus Keyamo, all of them making commentaries on the drug issue. And what Keyamo has said is that no, it did not forfeit, there was no case. Is there actually a case? So if there's a case, let's interrogate that there was a case and the forfeiture was based on a case, and you go on social media, you are all manner. The court, the Nigerian court, is the one that will make a final statement that will put these particular two to rest. If we do that, the issue of interim government, the president return did not meet up the threshold of the constitution, would have been laid permanently, would have been killed. Then we now focus on whether you want Imo or you want Rivers, where were the results from there, because those are more technical. You must prove your case beyond reasonable doubt at the polling unit. So you must justify that in polling unit 1 in Ohada local government area of Rivers State, I scored this vote, whereas this is the vote that came up. Then you cannot begin to pick them up one by one. But the issue in the public space, the court of public opinion, is not Rivers Imo results. It's not Adamawa result. It's not polling unit in anywhere. It is session 134 and the drug case. It seems to be like the biggest of the case. That case can easily be trashed without wasting time. Again, based on pace, I know our judicial system is a challenge. We drag out, and that is why there had to be that 180 days. You remember, the 180 days was imposed, that you cannot go beyond 180 days. Before now, previously in 2007, you saw how Oshomole's case went far in the case. So you see, the government, you are late, and 2 years after you are still in the tribunal, you are almost running up your elections. So the 180 days is actually an improvement. It's an improvement on previous jurisprudence. But there need to be, like Abokoba has said, let's radically depart. It's a radical departure. The word radical means swift. The word radical means that, yes, we know the norm.
Instant.
We know the norm. The norm will allow you this 180 days. The norm, the provision of 180 days did not say that it must be minimum. That is a mass. So you can actually do it in 1 week. And I think that the judiciary, with all the commentaries coming from within and outside of Nigeria, should do the needful. And for me, I have a proposal beyond just this. I think, too, people are also agitating for live telecast of the proceedings of the court. People want to know what was submitted, the argument. They want to know. The judiciary, as of this material time, must begin to think of quelling the tension in the nation by providing a transparent judicial process, particularly in the presidential election. Not necessarily because, I mean, you're going to go to all of the states. We may not have all of the laws to cover the states.
Also, let me just come in here quickly. We'll definitely continue on this toga of conversation, and we'll be right back after the short break. Thank you for staying with us. That's just to remind you that on Friday we will be having the Senior Advocate of Nigeria, Olisa Abakoba, joining us at 7:20 on Kakaki for this conversation that we are having right now. But in the meantime, Austin, please do continue.
So as I was saying, is that even though we cannot break this radical departure, that we may still go with the 180 days, can you show that everyone, locally and internationally, can focus? You see, I was in this country observing the Kenyan election, not the election itself, the judicial processes. I was here. I watched all of the processes. It was as if, how can we, if Kenya, I mean, with all due respect, Kenya is a country, but there's no comparison in terms of the popularity. This is the largest democracy, for Christ's sake. This is a democracy that should show the path for all other countries, particularly in Africa, to follow. Kenya, live transmission on YouTube, everywhere. It doesn't need to be on AIT because you say the cost is much. YouTube, it's just internet you need. Show us live what is happening, the proceedings. Show us live. The judiciary can have its own, just one camera in the room and then give feed to everybody. You don't have to have 200 cameras in that room. transmit it out, all of the stations, AIT, or everybody takes feed from there, and then they show it and broadcast it to the world. We need to see how the process is going. We need to see how the matter of 25% will be resolved. Many people, including myself, before the election, had also made commentaries about the 25%. That for me, if you have 5 credit in your WAEC, if the JAM says that a matriculation board, university regulation says that you need 5 credit and English, go and score 7 credit without English. There's no admission. That's English language. But the lawyers will have their interpretation clause and begin to have those interrogations. And the other agreement is that when you say state, in this FCT March 18th, we were working everywhere. All the states were shut down.
All right. Let me come to Barrister Maxwell. I mean, the speed of justice is the mantra that our judiciary must proclaim very loudly, and that's in the voice of Leonard Silk. But then perhaps a little clarity, because when he said the arbitrary tribunal will deliver what is called a partial final award, what exactly is that?
You know, I'm an arbitrator. See, in arbitration, there are some issues that you needed to trash out, just like what he said. If you watch what Olisabakoba SAN was saying, there are some issues that you need to trash out on that stage of that pretrial. The issue of double nomination, something like double nomination of the vice president. One, as at the time you were appointed as, you are nominated as the vice president, we are still having another nomination ticket for another position. These are the issues. If that one has been established at that level, then the issue of certificate, did you forge a certificate? If he said no, here is the original. You confirm it at that preliminary stage. All those particular issues can be dealt with. There are some, you don't even need evidence. The evidence are there. So when you now trash it out, then you now, if the issues, the ones you raise, has already disqualified the person, then there is no need of going into whether you win an election or you did not win. So that was the reason why, that's what Odisabakawa was hammering. Instead of coming to waste the whole time talking about something that you can just close your eye and give interpretation. I'm talking about judiciary, just like this 25%. Whom do you want to take evidence from? Whether is it a constitution that you are having for you to interpret? You say this particular issue, no, the panel have sat, look at our position on it. The issue of a forged certificate, these people say that the one you presented is fake. Do you have original? You compare it, settle it. As at the time you take nomination, they say that you are still having another nomination, which is against the law. We have it there, you have established it in several districts. You settle all those issues, then you now focus on. If we are able to resolve all those issues in favor of the person, then you now go into whether I win election or I did not win election. In fact, if you watch that, the issue of winning election, not winning election, even came last. So these are the issues that I believe the tribunal can take a clue from there. Remember that, because one, even that if you look at the number of petitions that are coming in and the way they are bringing it, you discover that that's 180 days. If you want to follow our own conventional way of trial, that 180 days will not be enough, because once you take any particular witness, a particular party may decide to take about 15 witnesses. Then another person, if there are, let's say, 7 that filed the petition, and each of them have 20 witnesses, when are you going to do it? Even if you are sitting morning, afternoon, and night, you can still not meet up. So we are looking at the most peaceful way of resolving these issues, and also to bring the attention, because if we go out, Nigerians are much interested. I've been going to court. In fact, the last time I went to court, what I saw in that court of appeal, I couldn't believe it. I heard them say, people from Bayelsa, people from Adamawa, people from, I heard them say, they were saying a lot of comments. I witnessed it, I saw them. So you see people that are angry, people that are following what is happening. So I don't know how the panel are going to do it. So, and the better for them, the only thing that will happen to them is, the best thing that will happen to them is for them to make it open. Because if you just, the one who just we hereby give decision, a situation whereby somebody from fourth, you are first, somebody who did not contest election, all those ones cannot stand though. I know what I'm saying. I'm a very strict guy.
Supreme
I know
Court
what people are
judgment.
saying. So the earlier we do it, the better for us. I think Odisabakaba has given them a leeway to do it, so that the tension, the expectation is high.
Thank you so much, gentlemen. We'll just hold your thoughts there. We'll have you on the other side of the device. But right now, I'm standing by to give us this issue and, of course, a lot of other trendy issues on social media. Ms. Joanna asked that you give us your concluding thoughts on the issues that we were talking earlier, particularly around the speedy dispensation of justice at the election tribunal. I'll start with you, Maxwell.
Just is a general advice. I think the panel should understand the nature of Nigeria now. They should try as much as possible not to allow the council representing the parties to delay the matter unnecessarily. They can still look at all those issues that will delay the matter, thrash it out at the preliminary stage. Considering the fact that the tension is high, they should look at all the whole matters holistically, and they should try as much as possible to give details of all the issues raised. Because if you watch the last presidential election, issue of certificate forgery and what have you were raised. But during the time of judgment, some of the issues were not captured in the judgment. But it's a Supreme Court judgment. You cannot appeal against it. You cannot question it. So they should try as much as possible so that all this tension that we are experiencing here and there can calm down. Then the lawyers on their own, you should know that this is your brief, not your case. Just present your case and allow the tribunal. If you have a bad case, you have a bad case. So the essence of trying to frustrate it so that the person you are representing can still be in the office or be sworn in, you continue to drag it, is uncalled for. It will go a long way of defeating the purpose of Section 285 of the Constitution. That's my parting words.
All right, Austin, how do you conclude?
First is that this is Nigeria, and Nigeria is bigger than every other person, including the institutions of Nigeria. The judiciary, particularly the Supreme Court, does have the highest level of integrity to keep Nigeria in focus and in shape. What do I mean? The judiciary must try as much as possible within the opportunity that it does have now to create that enabling environment of trust, because there's a huge trust deficit, particularly with the judiciary, because of the cases that have been cited before now. Somebody who didn't participate in election becoming a candidate, or somebody who came forth becoming was returned elected. Those are signals that people are being to use against the judiciary materially right now. To get that trust in focus, clear out some major cases. We have said that in those major cases, for example, interpretation of 25%, section 134, clear it out. Clear the issue of double nomination out.
All right.
Clear the issue of, and then above all, televise the proceedings. Let it be transparent. Let everybody see what's happening so the trust can be built and we can have a better Nigeria going forward.
Thank you so much, Austin Aibe, and of course Maxwell Okbara, who is also a lawyer, has joined us to talk about this issue. And like we said earlier, we'll be having this in Leonard Silk, of course, Abakuba joining us on Friday on this show to bring us highlights and speeds, updates on this particular conversation. In the meantime, we'll take a quick break and we'll return to discuss the issue concerning the alert plans to install an interim government pronouncement that was made by the DSS on alert quarters. We'll be right back.